I feel a little bit intimidated. I don't have any props following Dwayne here. I must feel like the guy who had to follow Clint Eastwood at the Republican National Convention. I don't have the empty chair or something. Yeah, I can find a chair somewhere, I'm sure. But I want to say just for a moment a few words about the Thomas International Center. We're an educational institute that helps students and others delve deeper into life's big questions, drawing especially on the classical and Christian sources of Western civilization and the natural law tradition of the American founding. The center has been sponsoring activities for a number of years, and last summer we made the decision to locate permanently in the Raleigh-Durham area, although we're also trying to put many things on our website as well to make them available around the country. I hope you'll have access to a brochure that we'll make available to you. Second thing I want to do is to thank the organizers here, especially Joe Rutten, Dwayne Spader, Troy Jones, Jean and Cynthia Jones, Larry Canfield, Stan Biondi, and Miles and Lisa Beacom. And there may be others I'm leaving out. I apologize if so. But without their initiative and dedication, we would not be having this seminar today. And we are very grateful to them, as I'm sure you are. The division of labor among the three speakers today is I'm going to talk largely about political issues, starting with describing the law and then giving some of the constitutional background and talking a little bit about what's behind the whole issue. Then my colleague, Fulvio de Blasi, will be speaking especially on principles regarding what's called moral cooperation in evil. That, what if you have to do something that's not evil itself but may indirectly advance evil? What are the moral guidelines for that? Because that's something that's involved in this whole mandate issue. And then the third speaker will be Frank Mannion, a lawyer for the American Center for Law and Justice, who will be talking about litigation related to the mandate. So let me begin then by talking about the mandate itself. Where does it come from? What is it? Basically, its roots are in the Patient Protection and Affordable Care Act, commonly known as Obamacare, which requires that health plans of employers with more than 50 employees provide preventive care for free. Free meaning without a copay, coinsurance, or deductibles. It might include things like flu shots or cancer screenings, blood pressure, diabetes, cholesterol tests, mammograms. Now, pursuant to this provision, providing for free preventive care, HHS, the Department of Health and Human Services, has issued rules that define the scope of coverage for these preventive services. These include rules based on an HHS-commissioned Institute of Medicine study defining what should be considered preventive services necessary for women's health and well-being. As is often the case, there are a lot of kind of interlocking background connections here between certain kinds of elites, and especially the people in government at HHS and the people in various, the New England Journal of Medicine or this Institute of Medicine, where they have a lot in common and share certain ideals often associated with other elites such as Planned Parenthood. Now, among the women's preventive care services were included contraceptive methods and counseling. And these are defined to include, quote, all Food and Drug Administration approved contraceptive methods, sterilization procedures, and patient education and counseling for all women with reproductive capacity. Okay, so that's part of the preventive care that's defined as required. Now, the plot thickens when we get to the fact that the FDA, the Food and Drug Administration, has defined, or maybe better said, redefined pregnancy. Most of us probably grew up thinking that, well, when the sperm and the egg meet, the egg is fertilized and that's when pregnancy begins. That is no longer the definition of when pregnancy begins. Basically, the FDA redefined pregnancy as beginning with implantation of the fertilized egg in the womb. Fertilization usually occurs in the fallopian tubes. The fertilized egg comes down the tube into the uterus and implants in the uterine wall, usually, say, 5 to 7 days after fertilization. Well, now that 5 to 7 days between fertilization and implantation is no longer defined as being part of pregnancy. That's before pregnancy. And therefore, anything that you do to destroy the fertilized egg between fertilization and implantation is no longer defined as abortion. It is now defined as contraception, as in emergency contraception. So things like Plan B and Ella are these so-called emergency contraceptives, although in fact, as we traditionally understood it, we would have regarded them as abortifacients. Now, part of the controversy regarding the mandate arises from the contention by some people that those who oppose the rule, by the contention of some of those who oppose the rule, that contraception and sterilization are not the only issues involved, because the rule obligates employers to provide coverage for drugs that sometimes cause early abortions. That's important because, of course, the number of Americans who oppose abortion is much larger than the number of those who oppose contraception. Now, the HHS also provided an exemption for certain religious employers. And the religious employers had to meet a 4-part test. First of all, they have to be, as defined by certain IRS rules, churches, congregations, or religious orders. Second, whose purpose is to inculcate religion. And third, they have to serve they have to serve people of their own faith. And fourth, they hire primarily people of their own faith. Okay, so if you're a church, congregation, or religious order whose purpose is to inculcate religious values, and you hire and serve primarily people of your own faith, then you qualify for the exemption. Now, this would include typically priests, ministers, perhaps parish employees who work, directly for the parish. Well, even that's not entirely clear. It excludes Catholic charities, Catholic relief, religiously affiliated hospitals and social welfare agencies. In fact, as some people have pointed out, it would not apply to Jesus, because Jesus, after all, cured non-Jews. Therefore, he served people outside his religion, and therefore would not qualify for the religious exemption. Note, it only applies to religious employers. It provides no exemption for private employers who have moral or religious objections to providing such coverage. So the bottom line is that they cut out this relatively very narrow exemption for certain religious employers. And one way to think of it, I think, is something like this. It's okay to have religious liberty as long as you become Amish. As long as you stay out of the public sphere, pull out of the public sphere into your own narrow private world where you and your fellow religious believers live, but stay there rather than going out into the public. Because if you go out into the public world, then you're obligated to act on the basis of the rules established by other people, in this case by the HHS. Well, not surprisingly, this mandate is highly controversial. The reason for this is that many individuals and religious groups have moral objections to contraception, sterilization, and abortifacients. Now, many of those who have objected to the HHS mandate don't themselves have moral objections to contraception, but they do object to the refusal to provide exemptions for those who are opposed to contraception. That's why, for example, a prominent Protestant minister, Mike Huckabee, who was, as far as I know, not opposed to contraception himself, was able to say something that, for a person my age, it would have been shocking when I was growing up. It's this nationally prominent public Protestant minister saying, "We are all Catholics," when it comes to the HHS mandate, because they understand that there's this key religious liberty issue involved. And it's not simply a question of whether they happen to agree with Catholic beliefs on certain moral issues. The question is, can Catholics be made to violate their own Catholic issues? Because, of course, if you can make Catholics violate theirs, then you can make Protestants and others violate theirs as well. So that's the background for what the HHS mandate is. Now, I want to now describe the overall development of American constitutional law regarding free exercise of religion. I'm going to keep it pretty brief. I'm not going to go into it in the detail I might, because I realize this is not the time and place to do that. If people have more questions about the evolution, I can talk about that later. Now, needless to say, freedom of religion was one of the liberties most cherished by the founders of American government. In the Constitution itself, there's an absolute prohibition of religious oaths to hold office. And the Constitution was quickly amended to include a Bill of Rights, which included the religion clauses, that is the Establishment Clause and the Free Exercise Clause. The core meaning of the Free Exercise Clause, which says that Congress cannot pass laws that prohibit the free exercise of religion. And for the record, that's been applied to states as well through the 14th Amendment. The core meaning of that was that Congress could not prohibit religious beliefs, nor could they prohibit religious conduct on religious grounds. Where the issue gets murkier and more difficult is the application of free exercise to secular laws that aren't religious on their face, but laws that have the indirect impact on people's religious beliefs that prevents them from acting according to those beliefs. There, I think, the founders thought that an ordinary, valid secular law could not be legally or judicially challenged on the basis of the Free Exercise Clause. If there was a secular law that prohibited something that you wanted to do as a religious believer or wanted not to do, then what you have to do is you have to go to the legislature and get an exemption from the legislature. And the founders, in general, believed in such religious exemptions. A classic example would be, probably the most prominent one in that era, was conscientious objection to serving in war. And in particular, the Quakers, who did object to serving in war. And in general, they were provided with a legislative exemption from the ordinary requirement of military service. So the founders would favor exemptions, but usually through the legislature, not through the judiciary. Now, the first era of American constitutional law regarding free exercise can go by the name of the secular regulation rule. And it basically says that the secular regulation is valid even if it incidentally impinges on religious conduct. Let me take a really obvious, extreme example. What if somebody who moves in next door happens to believe in an ancient Mexican religion associated with Montezuma, one of the central rituals of which is human sacrifice? You probably wouldn't feel comfortable if he had free exercise of religion in the sense that he could do whatever he thought was right according to his religion, because you might end up as human sacrifice, right? That's not going to work, obviously. Murder laws trump the claim of a religious believer to engage in human sacrifice. That's an obvious extreme example. Let's take something that's not quite so extreme and somewhat better known. What if you take a religious group like the Mormons, who head out to the Utah Territory, and one of the things the Mormons believe in is not just the right, but the duty of polygamy, having many wives. Congress was not happy about that. They passed a law basically prohibiting polygamy. The Mormons were prosecuted under it. It went to court, ultimately to the Supreme Court. And in 1878, in a case called Reynolds versus Sims, the Supreme Court upheld the law. They said, here you have a valid secular law that promotes monogamy, which is a good thing for society. It's not a religious law. It's a law basically providing for the stability of marriage as the foundation for society. And as a valid secular law, the Mormons can't claim that their religious beliefs require an exemption from that law. So that's called the secular regulation rule. And that was the dominant rule of free exercise law basically until about 1963. Okay. 1963, a new era is ushered in. This is the heyday of the Warren Court, and the Warren Court is expanding rights in various ways, and this is one of those areas. It began with a woman named Mrs. Sherbert, who worked Monday through Friday at a job in South Carolina, and then her employer decided to start having people work on Saturday as well. And Mrs. Sherbert was a Seventh-day Adventist. And like Orthodox Jews, their Sabbath is not Sunday, but Saturday. So Mrs. Sherbert tried to arrange to get out of that somehow or other. She couldn't. So she got fired because she wouldn't work on Saturday. She went to collect unemployment compensation. But if you've been fired for cause in South Carolina, you can't get unemployment compensation. And South Carolina said you wouldn't work on Saturday. That's one of the rules the employer has. So you were fired for cause, so no unemployment compensation. That case goes to the Supreme Court, and the Supreme Court overturns South Carolina's refusal to provide an exemption for Mrs. Sherbert. And the court institutes a new test for free exercise law that has two parts to it. And this is important for us later on, as we'll see. Number one, if the state is going to pass a secular law that impinges on religious conduct, the state needs to have not just an ordinary interest, it has to have a compelling state interest. A compelling state interest, a really high, important interest. Second, even if they have a high interest, the only way the law can be approved is if it is the least restrictive means of achieving that objective. That is, if there's some other way you can get to the objective without impinging on the religion, then you've got to choose that other way. Okay? So this is important. This is a new religious test. No, you have to have a compelling state interest and use the least restrictive means if you have a law that impinges on religious practice. And if you don't, then you've got to give an exemption to the religious believer from the secular law. Okay? Okay, that lasts until about 1990. And in 1990, the Supreme Court basically switches back to something like the secular regulation rule. Now, why did the Supreme Court do this? Again, it's complicated, but the bottom line was this. The court said, if we have to make distinctions between really important interests and not so important interests, how do we make that judgment? Is there anything in the Constitution that tells the judge, well, this is a really high interest, but this isn't? There isn't. And so in a way it makes judges policymakers. And the court, this is especially Justice Scalia, thought that that would be wrong to do. So, he basically had the court step back and say that if it's a secular law, if you want an exemption from it, you got to go to the legislature to ask for it. Okay, now does this mean that there was no longer any protection for religious liberty? No. Because there's another interesting case, and again, it's important for our discussion of the mandate down the road, and that's why I bring it up. It's a case coming out of Hialeah in Florida, and it involved a religious group called the Santerias, kind of an Afro-Caribbean religion that involved, among other things, like wringing chickens' necks, And they were moving in, setting up a church or something in Hialeah. And the city fathers in Hialeah weren't happy with the idea of chickens having their necks wrung in Hialeah as part of a religious ceremony. So they immediately passed a law basically prohibiting animal sacrifice. But in the law, they also provided a bunch of exemptions that permitted all kinds of animal killing. Obviously, hunters can kill animals, or more particularly, giving a religious example, certain kinds of kosher methods of killing animals to prepare them were exempted from the law. So it went to the Supreme Court, and the court said, well, look at these exemptions. You get basically the ordinance looks like an awful lot like it was passed specifically to prohibit the Santerias from doing their religious ceremonies. And yet you got these exemptions that lets, Orthodox Jews who want to have kosher food, kill animals their way. What's the ground for the different treatment here? Isn't that unfair to treat the different religions differently? And so the court, I think unanimously, in fact, struck down the Hialeah regulation. Now, plot thickens here. The Smith decision was very unpopular with a lot of people. And in fact, so many people that it ended up creating a very unusual congressional coalition. In fact, it involved a coalition between Ted Kennedy and the most liberal people in Congress and a lot of conservative people who were concerned about religious liberty. I think in the Senate, as I recall, I think the law that was passed in response to this was passed 98-0. And in the House, it was a huge majority as well. What was the law passed? What did they do? Congress passed a law called the Religious Freedom Restoration Act, usually referred to for shorthand as RFRA. And what RFRA does is basically attempt to reinstall the Sherbert standard that had been dominant on the court from 1963 to 1990. That is, the Religious Freedom Restoration Act basically said, in free exercise cases, we're going to go back to compelling state interest and least restrictive means. Okay? Well, not surprisingly, Supreme Court was not very happy about this uppity Congress trying to overrule them. And so, in a case a few years later, this is a case that came out of Texas, where the Archbishop of San Antonio wanted to expand a church that was too small, but it was in an historical district, and the city wouldn't let them expand the church because they had this historical landmarks law. And the bishop invoked RFRA, the Archbishop invoked RFRA, saying, this law can't be used to prevent us from, exercising our religious liberty to expand our church. Well, not too surprisingly, I guess, the case went to the Supreme Court and the Archbishop lost. Basically, the court reaffirmed the Smith decision and said, if you got a conflict between religious conduct and a secular law, as long as the law is generally applicable and neutral, not discriminatory, then the secular law wins. But there's a hugely important part of this case. This case involved a state, a city and a state. So it was at the state level. It's different, the court said, if this were a federal enactment. Why would that be different? Because the Free Exercise Clause creates a kind of floor. You have to have at least this much religious protection. But Congress is always free, if it wants to go ahead and provide more religious protection, to increase the amount of religious protection. So the Religious Freedom Restoration Act, which expands religious protection, is okay when it applies to the federal government. even though it's unconstitutional if it applies to the states. And that's really important for our purposes when we get to the mandate. Okay, let's apply this description of constitutional law and statutory law to the HHS mandate. I'm going to just say a few general things because Frank will go into more detail about the actual lawsuits and their arguments. I'm going to read you a statement from the HHS defending their mandate against the charge that it violates the Free Exercise Clause and RFRA. Okay? Okay. This approach, the mandate, is consistent with the First Amendment and with the Religious Freedom Restoration Act. The Supreme Court has held that the First Amendment right to free exercise of religion is not violated by a law that is not specifically targeted at religiously motivated conduct, as the Hialeah law was, and that applies equally to conduct without regard to whether it is religiously motivated, a so-called neutral law of general applicability. So they're summarizing the Smith standard there. The contraceptive coverage requirement is generally applicable and designed to serve the compelling public health and gender equity goals described above, and is in no way specifically targeted at religion or religious practices. So that's their argument about free exercise. They go on to say, likewise, this approach complies with the Religious Freedom Restoration Act, which generally requires a federal law to not substantially burden religious exercise, or if it does substantially burden religious exercise, to be the least restrictive means to further a compelling government interest. Period. End of quote. End of HHS comment. Now, notice in the quote that I just read to you, the whole thing, they give the free exercise argument, and then they give a response explaining why the free exercise argument claim doesn't apply. They give the RFRA argument, and then they don't give an argument about why RFRA doesn't apply, which is kind of bizarre. You know, they just kind of assert that this doesn't violate RFRA, but they don't even try to give an argument. Why don't they try to give an argument? I think there's a very simple answer to that. It's because there is no good argument on this. Is there a compelling state interest to provide, to compel private employers to provide contraceptives? Well, I mean, contraceptives are available at Target, you know, a month supply, what, for $9 or something like that? The law itself contains all kinds of exceptions. If it's so compelling, why do they allow all these exceptions? You know, is there really a compelling state interest? That by itself is highly doubtful. But where it especially gets to be a problem for them is this. Is it the least restrictive means to require religious people to provide this coverage against their conscience? What would be alternative means? The government could just set up a clinic providing contraceptives free to whoever wants them. And that would be very simple to do, right? There's so many other ways the government could do this in a way that's less restrictive that, frankly, the chances of the federal government, the Justice Department, winning that argument in court aren't very good, which is one reason why I think they didn't even try to give the argument here. For the record, while I think the government is likely to do better on the free exercise clause, even there it has some serious problems as well, especially with respect to, again, the exemptions. Go back to the exemption that the HHS provides. If you're a religious employer, you know, church, congregation, religious order, that inculcates religious values, that hires people of your own religion and serves people of your own religion, you get the exemption. Okay. Now the government is going to have to explain in court why it is that those people get an exemption, but let's say that you have an identical religiously affiliated social service agency, Catholic Charities or something like that, that serves non-Catholics. You give the exemption to the one group that only serves Catholics and only hires Catholics. You don't give it to the group that will serve non-Catholics. You tell me, what is the government interest that explains why you give the exemption to one group and not to the other? I mean, is there any kind of plausible government interest in doing that? Other than, fundamentally, hostility to certain religious groups that have certain religious ideas. I mean, this is basically a way of excluding religions that actively involve themselves in public activities. You know, the law has a kind of built-in preference to protect small religions that stay out of the public world, kind of live in a little private world of their own, but it won't protect religions that actually get into public life, doing things like helping other people, you know, with homeless shelters or soup kitchens or adoption agencies or, you know, any number of different things. You know, why? The government is going to have a heck of a difficult time explaining why they have that different treatment in the law under the free exercise clause. That is, they're going to have a difficult time showing that this really is a neutral, general law when it treats different religions so differently. Okay, so that's some of the legal arguments. I want to end with the last one of my talk, getting into the question, what is behind this whole issue? I mean, what has led to this HHS mandate and the controversy surrounding it? I mean, it is very striking that a U.S. presidential administration has decided to engage in what can only be called a direct assault on the Catholic Church. For there can be no question, I think, that the narrowness of the religious exemption is intended precisely to weaken and curtail the influence of the Catholic Church and other traditional religious groups, to drive them out of the public square because they don't adhere to a certain ideological vision. Now, these current events bring to mind a particular historical event some of you may have heard of. It's a 19th century event when the German Chancellor Otto von Bismarck engaged in an almost decade-long war against the Catholic Church in Germany. It was called the Kulturkampf, culture war, culture struggle. Basically, Bismarck, who was trying to unite Germany, didn't like the fact that over against the state, there was this powerful private entity, non-public entity, called the Catholic Church. He feared its influence, and so he engaged in a direct assault on it. Prussia passed legislation that included state control over the education and training of clergy, closing seminaries, prohibiting priests from discussing politics from the pulpit, the dismissal of Catholic teachers in public schools, the suppression of the Catholic press, the removal of Catholics from civil service positions in the government. At the height of the anti-Catholic legislation, half of the Prussian bishops were in prison or in exile. A quarter of the parishes had no priest. Half the monks and nuns had left Prussia. A third of the monasteries and convents were closed. 1,800 parish priests were imprisoned or exiled, and thousands of lay people were imprisoned for helping priests. Now, many people might say, well, gee, isn't this comparison kind of overdoing it? After all, things are not so dramatic in the U.S. today. Catholics certainly, aren't being imprisoned for their beliefs. And that's true up to a point. But maybe that's because shrewd persecutors would recognize that it's much more effective to use more indirect means, more indirect penalties. For example, to drive the church out of social service activities, such as adoption, or to impose heavy fines that drive out of business those who will not toe the government's line. In fact, the new persecutors will readily create fictions that attempt to provide excuses for religious believers to evade their moral responsibilities. For example, the HHS has fashioned a so-called compromise that has insurers pay for contraception, they say, rather than employers, as if the insurers didn't get the money they spend from employers' premiums. It's not imaginary that Catholics who are serious about their faith will find it difficult or even impossible to do business or to engage in certain occupations. Influential elites favor policies and laws that would make it difficult for Catholics and other pro-life Christians to be pharmacists in some places, or to get through medical school without receiving mandatory training in how to do an abortion, even perhaps participating in an abortion. There are states where attempts have been made to deny licenses to psychiatrists who will attempt to help people overcome homosexual inclinations. That so-called reparative therapy. There's been an attempt to say that if you believe in any effort to help a homosexual cease to be a homosexual, you have violated ethical standards and you'll be denied a license to practice psychiatry or psychology. What has led to this situation? As is often the case, the source of these practical evils finds its roots in ideology, in ideas. This struggle, and I want to remind you that the HHS mandate is only a part of it, can be described as an assault on traditional religions, such as Catholicism, by what I will call contemporary liberalism. Now, I want to be very careful, very clear here. I'm not using liberalism in the way we talk about it with, political conservatives and political liberals. I'm using it in the way a political scientist would talk about it. It refers to a certain political philosophy. Now, liberalism, historically, was part of a great cultural movement toward freedom, the elimination of hierarchies and rigid social classes. It involved things like the adoption of democracy, equal rights, separation of powers, and many of the other things we're familiar with. That's not accidental because the founders of American government were what people refer to as classical liberals. They believed strongly in liberty as the fundamental principle of political and social life. But in the 20th century, this liberalism has evolved in dangerous ways. Unlike the founders, contemporary liberal ideology has become hostile to traditional religion, especially when it's not purely private, but has social implications that people act on publicly. Liberalism, contemporary liberalism, has become deeply skeptical of moral absolutes, imposing in many venues what some people call a dictatorship of moral relativism. You're probably not so aware of that in Sioux Falls. If you want to go to one of the major universities in the country, you'll feel it very quickly because that philosophy is very dominant in the major universities of this country. In particular, contemporary liberal ideology has become deeply intertwined with an ideology of sexual autonomy. Control over reproduction is considered essential to equality for women to the point of destroying newly conceived human life. And that control over reproduction must be accomplished without limiting sexual activity. In fact, expanding the range of sexual activity. Now, the Catholic Church, together with other traditional Christians who share its views, is the single greatest institutional enemy of contemporary liberalism, because it prevents people from having sex when they want it, before marriage, without marriage, because it connects sex to marriage, and especially with lifelong marriage, because it proclaims an essential connection between sex and children and family, because it believes in parental rights that are an obstacle to liberal norms, since parents might say no to having an abortion or having contraceptives. Maybe you have wondered, like I, why is it so important that there be free contraceptives in a nation where very few people have any difficulty obtaining contraceptives? Well, there's one explanation is an economic explanation. Big pharmaceuticals can actually increase their profit line, since people can now use more expensive brand name contraceptives rather than cheaper generic contraceptives, because it's free. That is, somebody else pays for it. So there's an economic reason. But there's another reason, in some ways more insidious, I think, and that's this. If you have a copay or a deductible or co-insurance, somebody's got to pay for the insurance. And with a 14-year-old girl, that's typically going to be mom and dad. So if you have a copay, mom and dad find out that the school is giving the kids contraceptives. And it's been one of the essential planks of Planned Parenthood for years now that kids must have access to contraceptives without parents knowing about it, because parents might say no. So that's one of the reasons, one of many reasons, that lies behind why these free contraceptives are so important, in order to do this kind of end around parents. Now, a very important part of American political and social tradition has been the importance of what people call civil society. That is, it's the tremendous diversity of groups, organization, associations. A Catholic business leader groups is a classic example of that, which are responsibility for so much of the activity, the dynamism, the problem solving in American life. This rich associational life provides an alternative to a top-down or a statist approach to solving problems. Churches are a key element in civil society, but liberal ideologists often see civil society and religion in particular as divisive, as obstacles to uniform national policies under the aegis of government, which is what liberals often mean by increasing equality. Now, for a long time, this opposition to civil society has been seen among certain ideological liberals in the form of opposition to parental choice in education. In general, people, again, I'm not talking about political conservatives and liberals, where there sometimes maybe overlap, but that is, people committed to the ideology of liberalism generally are very hostile to private education, and especially parental choice in education, because they want to have a uniform national education that they argue is the basis for a united society. And they don't trust parents, and especially religious groups, not to be divisive. Okay? These days, we're seeing increasingly in efforts to drive religious social service agencies out of business, as in the case of Catholic Charities and adoption in both Massachusetts and Illinois, because they would not consent to placing children with same-sex couples. And we see it now in the Obamacare and the HHS mandate, which imposes a uniform rule promoting contraception and sterilization and abortion throughout our healthcare industry. For the record, we're not talking about it today, but there are other parts of Obamacare, significant parts, that basically provide the broad public funding for abortion that has been a goal of people for a long time now, in spite of the fact that the Hyde Amendment prohibits that and is still on the books. Now, It would be a mistake to see the HHS mandate controversy as a single passing issue. It's one of the first great battles in the new Kulturkampf. Bismarck ultimately called off that war against the Catholic Church because Catholics overwhelmingly rallied to the faith and opposed Bismarck's efforts, and the political costs were too great to him. He had to back off. The situation today is somewhat different because, frankly, we are coming out of a period of time, the post-Vatican II confusion in the Church in Europe and the U.S., when many American Catholics developed divided loyalties, wanting to remain Catholic without following the teaching of the Church on important matters, especially sexual morality and especially contraception. Fortunately, we are coming out of that period now, having had the extraordinary leadership of John Paul II and Benedict XVI. The U.S. bishops are now providing a great deal of leadership, and many Catholic laity are understanding more and more their special vocation to bring the gospel to bear on the multitude of ordinary temporal realities, work, family, social and political life, that are the stuff of their daily life. Again, the Catholic Business Leader Groups is a great example of that. The HHS mandate, therefore, is a seminal event. It has to become an occasion when people understand more clearly the forces that are aligned against the Church and traditional morality, and which endanger the capacity of Catholics and other Christians to participate in public life, instead of confining their religious beliefs to their own private world. Catholics and others must rise to this occasion, insisting that they will not be shut out of our national debate and decision-making. They have to respond to the call to participate in public life and to articulate fundamental principles of morality and justice in the public square. They have to make known the truth that sets men free. Thank you.
We're going to have a panel discussion at the end of the other two speakers. So if you have questions right now, we can take a few minutes and take them, and I'll let Dr. Wolf address those.
You mentioned briefly the Hyde Amendment, and I was going to ask you if that still is force of law, if it's still the law of the land.
The good guys think it is, and the bad guys don't.
Okay.
Is the short answer. That is, the argument that will be made on the other side is that when you have two pieces of legislation that are incompatible, the assumption is always that the most recent one was intended to modify or change the earlier
So
one.
Obamacare is going to trump the Hyde Amendment, probably?
That's what the Justice Department is arguing.
Okay.
Now, I think there are actually pretty strong legal arguments on the other side, given the clarity of the Hyde Amendment and the lack of any clarity in the Patient Care and Affordable Patient Protection and Affordable Care Act. There's nothing explicit there about any intention to overrule the Hyde Amendment. And in fact, there's not very much explicit that could be used as a ground for arguing that it should modify the Hyde Amendment. So I think the argument can be made that the Hyde Amendment is still in effect, and the parts of Obamacare, especially the parts of the HHS rules that are incompatible with it, are illegal.
Then one other quick question, and that is, the mandate, can the mandate be unmandated by a new administration?
Yes.
Okay.
One of the key facts of modern politics is that a lot of legislation is basically these vague general things that Congress passes, and then it gets fleshed out, and a huge amount of the actual legislating gets done by administrative agencies, independent regulatory commissions, and with little or no guidance actually from the law. I mean, the law will have some really vague statement, and then the administration gets to promulgate rules to so-called carry it out. There was, in this case, it has terrible implications, because under an Obama administration, that's being used in all kinds of very harmful ways. The good news is that if the Obama administration is replaced by somebody who has a better understanding of the issues, then they can simply, overrule that policy.
Yeah, the law does not need to be overturned.
You don't have to overturn Obamacare itself.
Policy can be reversed.
Right.
Okay.
Well, the Kathleen Sebelius and the Obama administration has kind of bought into Planned Parenthood scheme, and I would make the distinction between mandate. Sometimes people say that mandate, there's a difference between the contraception, abortion mandate for that particular thing, and the broader mandate is where the Affordable Patient Care Act tried to provide that insurance had to be purchased for everyone. And that was one of the big struggles was, well, and that was their big argument. Well, we're all in this together, and you hear Obama say it at the convention, how we're together in this thing, and that's where the mandate is, that we're going to provide this blanket of coverage. And then it was left, the details, where the devil was in the details, and that's where Kathleen Sebelius, and who, by the way, is a Catholic woman, and presumably, and have forged this argument that contraception and other things should be involved in that. And I think we kind of got sold out short when this details were being discussed in Congress, and the guy from Michigan, I can't think of his name, but
Mark Stupak.
Mark Stupak kind of bailed out on us.
He's actually condemned the HHS mandate as illegal, but
But I see that if there's more potential pressures, that maybe they're going to redefine what some of this preventative care is. Maybe they can broaden exemptions. Are there other loopholes that we can get into? Obviously, it'd be nice to maybe consider throwing the whole thing out, the baby with the bathwater. I don't know. It depends on how you look at it. But there's a good chance that Obama's going to get reelected, and we're going to be fighting these other battles in other avenues.
yes.
I thought your explanation of the legal precedents was quite good in talking about free exercise, and what I heard you say was that, various institutions have tried to build churches or engage practices which are really religious. Is there guidance from the court as to what is a practice of religion? I mean, when a church starts a hospital or runs a hospital which is a public institution receiving public funds, is that the practice of religion?
Well, the big problem for us after the Smith case is decided in 1990 is not so much what the definition of religion is, it's what the definition of a neutral, generally applicable secular law is. The court is actually pretty open about defining religious acts pretty much as what people say religious acts are. I mean, there's a problem with sincerity. Sometimes people can manipulate exemptions. So, for example, in California, the California Supreme Court at the end of the 1960s basically said that peyote was central to the American Indian religion, and therefore they had to get an exemption from controlled substance laws, so that they could smoke peyote. Well, as you can imagine, there was a religious revival in Southern California after that decision, right? Because people went out and they claimed that they were doing it for religious reasons. Or one of my favorite was the group in Southern California that had as their central institution priestesses who would have sex with religious believers, in return for which they would leave an offering, basically it was religiously defended prostitution. They lost, I'm happy to say. But as did by the way, that group before I mentioned, that there was a group formed called the League for Spiritual Discovery, as in LSD. So when it comes to religion, there's a sincerity problem, but most of the time, unless there's some serious reason to doubt sincerity, you accept that the religious claim is a sincere one. The key thing about religious liberty is the question, do you give protection even to acts that you think are kind of ridiculous? I mean, isn't the whole point that different religions disagree about what's ridiculous and what's good? So for example, there's a famous case in the 1940s where Jehovah's Witnesses said, that their religion, the Bible, required them not to salute the flag. Because when you salute the flag, that's worshiping a graven image. Well, I think that's a nutty interpretation of Deuteronomy myself, but I have no doubt that the Jehovah's Witnesses were absolutely sincere. And eventually the court protected their right not to salute the flag. You know? So when it comes to religious belief, the court pretty much accepts, you know, unless there's serious reason, you know, to doubt sincerity, that what you say is conduct based on your religion is that. The problem is that under Smith, in a way, whether your conduct is religiously motivated just doesn't matter. If you have a secular law, that is, the law doesn't deal with religion as such, it's just dealing with some kind of secular matter, and if it applies to people equally, it doesn't kind of pick and choose, then that's going to trump the religious claim. You know, the religious believer can't get the exemption. And as I say, it's complicated why the court did that. But you know, that's the problem, which means unless we can show that there's some kind of discrimination in there, we're going to have a tough time using the free exercise clause itself. Although, as I suggested, I think there is discrimination in there when you look at the different, if you look at how narrow the religious exemption is. Our real, in my opinion, the real foundation for litigation, and Frank will talk about this more, is RFRA. The Religious Freedom Act, I think, or Restoration Act, I think provides a very powerful argument that we can invoke to defend our rights.